So our next panel is on Section 1 in the criminal law context, and the chair of the panel is Justice Jonathan Brunet from the Ontario Court of Justice, and he will lead us on this panel. And I'd like to introduce him to speak. Thank you.
Good afternoon, bon après-midi. I will just introduce the members of the panel that are up here. J'aimerais juste vous présenter tout le monde qui est ici à la table avec moi. À ma droite, c'est Monsieur le juge David Paciocco. I think most people know Justice Paciocco as the U of O rock star. Recently appointed to the Ontario Court of Justice. In fact, he and I were appointed around the same time. And I hate to say this, but I felt like the juggler who followed the Beatles on the Ed show. This man has an awesome resume. I won't go through it, but he's known as a teacher of criminal law, trusts, and evidence. Donc, vous connaissez assez bien Monsieur le juge Paciocco de ses années ici à l'université pendant 29 ans. En fait. On my left is Professor Carissima Mathen, also a professor from the University of Ottawa. As you know, she teaches constitutional law and criminal law. And further along is Professor Richard Jochelson from the University of Winnipeg, who also lectures in criminal law. Donc, les professeurs de l'Université d'Ottawa, le professeur Mathen et le professeur Jochelson, les deux sont des professeurs en droit criminel. Donc, on est chanceux d'avoir quelqu'un qui vient de Winnipeg, de nous rejoindre. So, as you know, the topic, you can tell from the schedule, is Section 1 in the criminal law context. And each presenter will have 15 minutes. Chaque personne aura 15 minutes pour faire sa présentation. Après cela, il y aura une quinzaine de minutes pour des questions, si vous avez des questions. Following the end of those presentations, you'll have an opportunity to pose some questions. We'll be calling on Justice David Paciocco first to talk about the area of Section 1 that passions him.
Thank you very much, Justice Brunet. Is my PowerPoint up and loaded and ready to go?
Yes.
Okay. Well, I made a lot of sacrifices when I left the university to go to the court. I gave up a job that had sabbaticals, summers off, and working with optimistic, enthusiastic young people. And now I spend my time with a less inspiring cast of characters, as well as accused people and witnesses. But the hardest part of leaving here is that I'm not allowed to criticize judicial decisions. And for someone whose stock and trade was criticizing judicial decisions, I feel a little hamstrung. The most boring speaker you could possibly invite to one of these things is a judge. I hope you understand that. But I'm going to deal with the boredom factor by basically taking the license to repeat things I've already said. I'm not going to say anything scandalous that I haven't said before. I want to talk in the brief few minutes I have about both important components of the Oakes test. I want to talk a little bit about the one we tend to focus on less, which is its commitment to the presumption of innocence. And then I'll talk about the Oakes formula. And with respect to the Oakes formula, the theme I'm going to present is fairly straightforward. It's that this formula is not so innovative and inspired as we like to think. I think it was obvious, and I think it's perfect. I think that the Oakes formula is really exactly what it should be. And there's no problem whatsoever with the structure of the legal tests. The problem with it, and I do think there are problems with it, is with its application. It is not used optimally, in my view. And I think this test should have broader sway, and I'm going to introduce you very quickly to a couple of the concerns I have. But I want to begin at the beginning. I want to begin with the presumption of innocence. Justice Dixon, Chief Justice Dixon at the time, recognized that Section 11D has as a minimum the following elements, and he talks about the requirement that the individual has to be proven guilty beyond a reasonable doubt, that the state must bear the burden of proof as well as making out the case against the accused, the case to meet principle, and what I call the constitutionally moot element, that trials are to be conducted according to lawful procedures and fairly. And I say that's moot because you don't need the Constitution to enforce lawful procedures. You can use ordinary rules to acquire that. And so what the contribution of the presumption of innocence jurisprudence is really primarily the reinforcement of the burden of proof on the Crown and the standard specifically of proof beyond a reasonable doubt. Now, it may seem obvious to a 21st century lawyer that the presumption of innocence carries with it the requirement of proof beyond a reasonable doubt. But remarkably, that was never specifically guaranteed in the Charter. And it took the Supreme Court of Canada to recognize that this is inherent in our concept. And the court recognized that any legal rule that could permit the conviction of someone in the face of reasonable doubt is in prima facie violation of the Constitution. And again, that may seem like a fairly trite observation, but for those of us who lived through the Canadian Bill of Rights Act before the Charter, this is a major development. In Wilmington, where the concept of proof beyond a reasonable doubt was affirmed, the court said that's the rule unless a statute says otherwise. So the commitment to proof beyond a reasonable doubt was fragile. Justice Laskin basically said in one of his cases that it's self-defeating. We're effectively guaranteeing it to you unless we don't give it to you, was what the rule amounted to. But now it's a prima facie violation of the Charter. And as I always tell my students, if you want to understand the law, you've got to get behind it. You've got to figure out why the rule is there. You've got to understand its rationale. And Justice Dixon did a beautiful job of telling us why in the Oakes decision. This is one of my favorite passages in all of jurisprudence. It's wonderful prose, almost bordering on poetry. But he tells us exactly why the presumption of innocence is so foundational. He calls it a hallowed principle underlying the heart of the criminal law. It protects the fundamental liberty and human dignity of any and every person accused by the state of criminal conduct. An individual charged with a criminal offense faces grave social and personal consequences, including potential loss of physical liberty, subjection to social stigma, and ostracism from the community, as well as other social, psychological, and economic harms. In light of the gravity of these consequences, the presumption of innocence confirms our faith in humankind. It reflects our belief that individuals are decent and law-abiding members of the community until proven otherwise. This, to me, is the heart of the case. This is why we embrace the presumption of innocence. It is a reflection of our belief in the dignity and worth of every individual. And it's a requirement that imposes tremendously high standards of proof on the prosecution because of the horrid consequences that a prosecution entails. And if you understand the why of the rule, you might also come to grips with the fact that the presumption of innocence doesn't speak so loudly in the bail context, where individuals will not be saddled with a record as a result of the consequences, regardless of how horrid they might be for the liberty of the individual. We tone down the presumption of innocence in that context. And we tone it down with respect to peace bonds, because a peace bond is not a conviction, and it doesn't saddle you with a criminal record. And so it helps us understand the calibration of the role of the presumption of innocence if we bear in mind exactly why we have it and what role it pertains. That case, of course, struck down a presumption in the then Narcotics Control Act that anyone who possessed narcotics was presumed to traffic in it. The burden was on the individual to disprove that they wanted to traffic. Well, there's a huge difference between trafficking and possessing. You grow a few marijuana plants and you're going to end up with a minimum sentence. You possess a clipping from a marijuana plant and you're probably going to get a discharge or maybe even a diversion. It's a huge difference, and to put individuals at risk on the basis of simple possession, on the theory that they must be trafficking, was not rational. There was no logical basis or connection. It was a rule of convenience, and it was efficient, but it undermined the integrity of the presumption of innocence, and the court wouldn't have it. Well, the legacy of this presumption of innocence has not been as strong as some of us might have thought it would be, because reverse onus provisions and mandatory presumptions have all been upheld by the Supreme Court of Canada, other than Oakes in one other case, where they've all been saved under Section 1. In the Lava case, we see the court lowering the standard that the accused must present the defense with respect to possession of precious metals, but otherwise, we have used Section 1 very aggressively to permit the prosecution to benefit from these presumptions. And I'll return to why this happened later, but I want to move on to the Oakes formula itself. The Oakes formula, of course, gives language to the very vapid and impractical language of Section 1. This is a horrid formula. It's filled with weasel words if you look at it. Reasonable limits, demonstrably justified in a free and democratic society. What exactly is demonstrable justification? What's a reasonable limit? And what societies, I suppose we can debate, are free and democratic? And it's also impractical if you take it at its face, because in the early cases, lawyers were running out doing comparative law research. For the average practitioner to be able to go out and find out what's happened in 15 other jurisdictions to see whether they have similar rules is an impossible exercise. True comparative law requires an understanding not only of text, but of legal culture and the operation of precedent. And it made it impossible. And what the court did in Oakes was incredible. It removed, really, the impact of the language of Section 1 and came up with a formula that has, as I say, 3 components, but really 5 elements. Prescribed by law component. Basically, that's telling us that we're not going to allow someone to abridge fundamental charter rights unless we have a law that authorizes it. The necessity component. We're not going to do it for any old standard. It's got to be something that's pressing and substantial. And it must be proportional. What does that mean? There has to be a rational connection between the measures taken and the results that you're trying to attain. It cannot be an arbitrary connection. It's got to be something that logically follows and is supported. And this is a reasonable way to go about doing what you're doing. Minimal impairment. You want to violate the charter? Don't do it any farther than you have to. That's really all that means. And then the cost-benefit analysis. The language gets very high flown in the cases, but basically this third element of proportionality test is just saying, is it worth it? Given the damage that we're going to do to the constitutional right, in order to achieve that benefit, does it in fact achieve sufficient benefit to make this a worthwhile enterprise? It's kind of like the only spot where we get a comparative evaluation of what is being achieved by the law that's being attacked and what the implications are. Well, to understand this formula, what you basically have to do is you have to really, again, look at the purpose behind it. You have to look at the objectives of the provision. And the problems that you're going to find are going to be problems of application, because this formula is exactly the sensible formula that you would expect to arrive at. When can we do this? Only if there's a law that supports it, not based on the arbitrary decision of an executive or someone who's appointed. When can you do it? Only where it's necessary. And based on necessity, it must be necessary enough to override a constitutional right. Not just, is it something that the state wants? Is it something that the state feels they need to get their way? Perhaps, but it's got to be an important enough issue to justify the imposition of limits. The rational connection test, it cannot be arbitrary. It cannot be unfair. It must be rationally grounded. The statute, the objective, the technique has to perform what it's meant to perform and not produce some collateral, unproductive result. And it can't go any farther than it has to. And finally, we're going to step back and ask that basic question. Is it worth it? Is it worth it? And obviously, in Laba, the Supreme Court of Canada said we don't have to violate the presumption of innocence to the point of having a reverse onus. We can sufficiently protect precious metals by having a mandatory presumption with a lower burden on the accused. That's a wonderful formula. And Justice Dixon, again, explains to us why. And in this passage, what he's effectively saying is, what you have to remember is the issue is, when is it appropriate for the government to remove a fundamental right? Something that they have guaranteed, something that they have promised. When is it appropriate to renege on a constitutional promise? That's what Section 1 is meant to accomplish. And that's unfortunately not how it is always applied. I have a number of concerns as to where the law has gone. The first is the loss, and that's a bit of an exaggeration. Let's just call it the jeopardy of the prescribed by law requirement. The prescribed by law requirement, of course, requires that there be a law in place, but the jurisprudence has been quite receptive to actions of the state in treating it as law. It can be implicit, for example, in Thompson, where you have a roadside breath test and it's going to take a long time to call a lawyer. Well, let's not give you the benefit of Section 1. There's nothing in the Highway Traffic Act or any other legislation that says that. The court was content to imply it. And when you start applying something as a constitutional limit, it gets a little dangerous. You'd like to think that if you're going to violate the Constitution, you're going to say it, you're going to say it clearly. In addition, we have the Greater Vancouver Transportation Authority case, where we allow a delegated body to effectively create a regulation. It's not a regulation in the sense that laws are regulations. The court said they have the statutory power to create regulations. Well, take a look at the statutory powers that were used to give this authority. They are nothing more than what you see in articles of incorporation of a company that says you can pass regulations for the purpose of administering your company. And that was treated as law for the purpose of limiting the constitutional right of freedom of expression. And I've got problems with that. I think that you have to put a higher standard on the imposition of limits than to allow this type of policy making to determine whether or not you have compliance with the Constitution. But that might be a bit of a quibble because the prescribed by law element is never really what things turn on. The substantial evaluation goes beyond after that. The decline of the variable approach with stricter application in singular antagonist cases. What I mean here is that in criminal cases, the court used to say very resolutely, look, this isn't just a dispute between two people that the government's brokering in its law. This is the state against an individual. And if you want to limit constitutional rights when you're prosecuting somebody, we're going to be even more rigid than we will be, where what you're trying to do is broker a dispute between individuals by simply settling the allocation of resources. That's a sensible doctrine, but we don't see it with the same commitment that we once did. The internal balancing problem is really a problem, being shy on, gun shy in Section 7. Section 7, of course, guarantees that everyone has the right to life, liberty, and security of the person, and the right not to be deprived thereof, except in accordance with the principles of fundamental justice. Well, you have the right to full answer and defense. You have the right to cross-examination as an accused. Those can't be absolute rights. They have to have qualifications on them. But when they're qualified, your principles, those principles are in fact compromised. They're infringed. But the Supreme Court of Canada felt that the language was so powerful in Section 7 in the motor vehicle reference case that they basically said Section 1, it's almost inconceivable that it could ever limit fundamental principle of justice. So what did they do? Given that it was inevitable that you have to compromise these principles, they started internal balancing. They said that if you have competing principles of fundamental justice, then there's no prima facie violation. In other words, you balance privacy of the victim against the full answer and defense of the accused or against the right to cross-examine. But think of what that means in application. If you're doing the balancing at the prima facie case stage, that means the burden's on the person bringing the challenge to justify that the balance isn't appropriate. And it means that all the detailed formula in Section 1 with all these brilliant questions that you'd expect to rationally be asked are not being asked. And I think it's a real problem that we were afraid to use Section 1 to deal with Section 7 initially because we thought Section 7 was so important. The net result is we've really watered it down and we've made it unpredictable and difficult to apply. The last points I know are going to be dealt with later in the discussion, but I have a slightly different take on it than Professor Jochelson. Professor Jochelson, as I understand it from the very short blurb, and I apologize, I won't be able to stay for his presentation, is going to suggest that the Oakes test has contributed in other areas. And what I was going to suggest is we need to make it more definitive and clearer, and specifically with respect to the Waterfield test of police powers. The Supreme Court of Canada was invited to adopt the same test, the Oakes test, of deciding whether the police have implied powers. And the majority of the court, I don't think, did so. I think they basically left it much more fluid. They left a list of factors to consult. And there's a big difference, in my view, between listing factors and specifically saying, apply each of these tests, and you have the burden, and you have it on the balance of probabilities, and you have to present evidence. So I think it's a bit of an opportunity lost. Anyway, thank you so much for your attention. Unfortunately, I've got to get back to court. Life wasn't like this when I was a professor, you know. We could leave at 3 o'clock, go golfing, take the summers off. Somebody should have told me that before I accepted this job, but now it's too late, so I'm going to run.
I'll hold down the chalk here while you're Next presenter is Professor Mathen.
Thank you very much. I'm really delighted to have been asked to present today, and I would like to just indulge and take this opportunity to welcome my criminal law small group, whose class I had to cancel, and so I made them all come here. The title of my talk is Rational Connection, Section 1 and the Charter's Legal Rights. So last term I actually gave an interview to the law student newspaper, and I was asked to name my favorite Supreme Court of Canada decision. So you know how it is, you've only been doing something for about 20 years, and someone puts you on the spot, and all of a sudden, oh, if I had to pick, which one would it be? And I'm fortunate enough to have had a previous career as a litigator where I was able to work on some pretty formative cases, charter cases, and I have experienced the thrill of getting a decision from the Supreme Court that actually vindicated the position that my organization took. Some examples include the decisions in Derrick, Chuck, and Greened. From a totally different vantage point as an academic, which David, of course, unfortunately no longer has the luxury of doing, we know that it's a lot more fun to critique a decision than to praise it. There's nothing more soul-destroying than to sit down to write a case comment about a decision and realize you actually agree with everything it says. So favorite could include the category love to hate. And let me just assure you that there are a legion of cases in that category for me. But I didn't pick any of those cases. Before I really even had time to think about it, I said Oakes. And I think it's fair to say that in my former role as a constitutional lawyer, I had at best a muted appreciation of the decision. Oakes is so strongly identified with Section 1 that it's often easy to overlook it as a case in its own right. You just identify it with the conventional doctrinal framework that it represents. And over the years, particularly in the course of teaching criminal law, I have come to appreciate Oakes in a different light. Alors ce que je veux parler ici est un aspect de l'article 1 qui n'est pas souvent discuté, et ça c'est la notion de lien irrationnel. Comme vous le savez, dans l'arrêt Oakes, juge en chef Dixon a déclaré que la première étape dans l'analyse de la proportionnalité était de démontrer un lien irrationnel entre l'objectif de la loi et de ses moyens. La loi ne peut trahir les suppositions arbitraires, injustes ou irrationnelles. Dans cet article, je propose que l'arrêt Oakes en fait établit une approche qui produit des résultats plus justes dans des contestations judiciaires au droit pénal. So briefly, I'd like to make 3 points. First, I want to talk a little bit about the role that rational connection plays in Oakes itself, and a suggestion as to why it was developed the way that it in fact came to be. Second, how has rational connection fared in post-Oakes criminal jurisprudence? And then finally, why a different approach, which I'm advocating for, would actually be desirable. So, to turn to my first point, one could be forgiven for assuming that the case which provides the template for all future Section 1 analysis would actually have proceeded through all of the 5 stages of the Section 1 framework that Justice Paciocco set out. Of course, this is not what happened. The Supreme Court ruled that the reverse ownership provisions in the Narcotics Control Act did not have a rational connection between its purported goal, deterring drug trafficking, and its means, namely imposing on the accused the burden to demonstrate lack of intent. As Robert Sharp and Kent Roach have recounted in their wonderful Dixon biography, Oakes presented as a garden variety criminal appeal. I would describe it as a kind of sleeper case. It attracted no attorneys general interventions, nor any by public interest litigants. It rose through the system, mostly unnoticed. And indeed, it is striking when you actually read the decision how little of Oakes deals with Section 1. Much of the case is focused on definitional questions concerning Section 11D. And because I'm a bit of a geek and I do these things, I actually counted, and fully 2/3 of the mention of rationality, or rational connection in Oakes is not under Section 1 at all. It comes under the discussion of presumption of innocence. That's because in previous cases, rational connection was considered a potential procedural safeguard in reverse onus provisions, to the extent that it would require, at the very least, a basic relationship between proved and presumed facts. As it turns out, of course, this was judged not to be a sufficient safeguard, because even with a mandatory presumption that demonstrated this rational connection, you still could have a trier of fact that would have to convict in the presence of it with a reasonable doubt. And so in Oakes, Justice Dixon stated that a more suitable role could be found for rational connection under Section 1. And that role is to provide a first check of the state objective that has already been judged to be important. Is it achieved in ways that are neither arbitrary, irrational, or unfair? Turning to the reverse onus provision, Justice Dixon stressed the need for internal coherence. In this case, a connection between the basic fact of possession and the presumed fact of possession for a particular intent. He warned of the ultimate risk of getting it wrong, of course wrongful convictions, and he concluded that the law failed the first stage of proportionality because it would be irrational to infer that a person had an intent to traffic on the basis of possession of a very small amount of narcotics. And so I argue, when examined closely, rational connection in Oakes is a species of overbreadth, namely a criminal provision that predictably risks convicting persons who do not meet the prescribed elements of an offense will be described as irrational. That is a startling, and I argue, a powerful conclusion. But Oakes was confronting a particular legal question: the appropriate balance between the presumption of innocence and criminal justice administration, in which the role of rational connection would relate primarily to a provision's internal coherence without much need to anchor it in broader policy concerns. And as was made clear only 11 months later in Edwards' books, Justice Dixon's approach, namely to collapse logical incoherence with anticipated over-inclusion, that approach would wither in the face of different competing interests. And so ironically, the criterion that decided the issue in Oakes would prove to be almost entirely toothless in subsequent cases. Instead, one tends to find a rote recitation that a law must not be devoid of all reason. As Justice Paciocco mentioned, even in other reverse onus cases, like Chollick and Downey, the court seemed quite ready to accept overbroad presumptions in the name of administrative expediency. The court's retreat from the high watermark of Oakes can perhaps be explained in part by the nature of the questions it was facing in subsequent charter disputes, especially those which involve conditions of imperfect information, as Janet Miner mentioned, conditions of empirical uncertainty. Although initially the court implied that judicial deference would be less appropriate in criminal law, it appeared to realize quite soon that rights come into conflict and the legislature must balance competing interests in criminal law no less than in other areas. And so the court, or majorities thereof, quickly accepted that Parliament need only have a reasonable apprehension of harm to demonstrate a rational connection between, for example, hate speech laws and protecting minorities, or obscenity laws and the inculcation of antisocial beliefs or attitudes. Now, one example where I argue that rational connection became determinative is Morgenthaler. There, a majority of the court concluded that therapeutic abortion defense in the code failed proportionality at every stage. Justice Dixon's analysis was the most comprehensive. He termed the defense illusory because it contained administrative burdens wholly unrelated to its alleged purpose. A second example is Rodriguez, which dealt with the crime of assisted suicide. Writing for the majority, Justice Sapinka stated, "The principles of fundamental justice do not require the state to remove all obstacles to procuring one's death, reasoning that the sanctity of life is still strong enough to prevent such a duty from emerging." Justices McLaughlin, as she then was, and Lerudubé dissented. They argued that the state's commitment to the sanctity of life, entitling it to triumph even over personal autonomy, cannot be inconsistently maintained, where to do so would result in arbitrary burdens. In this case, on persons with severe disabilities who are simply unable to exercise their own agency. But these counter-narratives are few and far between. Now, my focus on rational connection might appear unwarranted, the product of too much time spent in the ivory tower. Because of course, if its most promising element in Oakes is really the one that draws on overbreadth, well, we can consider overbreadth in the other two stages. But I will be arguing in this paper that more careful attention to rational connection could provide a counterbalance to the ever-expanding resort to criminal law in a climate where evidence-based reasoning largely has been discarded in favor of ideology and positivist lawmaking. The focus on evidence, combined with a stringent approach to rights protection, which suggests caution and restraint in the face of imperfect information. It also would permit a more searching inquiry of criminal laws which operate in some relationship of mutuality. Thus, for example, one could demand some explanation of how greater use of mandatory minimums relates to the protection of society, or why polygamy alone among intimate relationships should be singled out for criminal sanction. A recent example of this more searching version of rational connection can be found in the decision of Bedford. In the interest of time, I won't go through that, but that is the decision of the Ontario Superior Court of Justice, which struck down several prostitution-related offences in the code, reasoning that in their relationship, in their mutual interactions, they actually pulled against each other's objectives. So in my view, it's time to contemplate a deeper analysis of rational connection than has tended to feature in case law. A more attentive regard would demand some explanation of criminal provisions which are part of a broader criminal law policy but operate in an incoherent manner. Now obviously criminal law can embody different policy goals, but these goals must not be mutually contradictory. In my opinion, forging a path of this nature would be closer to Brian Dixon's original vision of the role of Section 1 and would more appropriately recognize his tremendous contribution to charter jurisprudence. Thank you.
Professor Jochelson.
While I'm, can you hear me okay? While I'm waiting for the PowerPoint to load up, which as you can see is a very technologically advanced PowerPoint. I just want to take a minute to thank our hosts today, and in particular the OLR, Rachel Gold for your constant communication and organizational skills, and of course all the members of the editorial team, and of course the staff advisors, Dr. Malhotra and Professor Power, and of course the entire faculty and student body that's come to support today's symposium. So, is it up? Okay, good. So today I'm going to speak, I suppose, in not opposition, but I guess in some tension to Justice Paciocco's claims that courts have not perhaps embraced the Oakes calculus enough in other tests, such as the Waterfield test, or what I refer to as the ancillary powers test. So I'm just going to, do I have a clicker? Yeah. Why is this it? Sure. Okay. I think we're not at the beginning of this part, but hold on 1 sec. Okay. All right, so I think I'd start with a rather contentious claim here, and that is, but I think it's a claim we have to start with, and I think the conference has largely supported this idea, and that is that, in point of fact, Oakes, we've heard today, is something of a gold standard in justificatory reasoning. And I think I want to start with that as a beginning, but I think we also have to keep in mind that, as Carissima said at the end of her talk there, that there's this positivistic evolution with Oakes, where maybe we've come to believe that as we've increased access to liberty-defining constitutional rights, somehow we've actually decreased them, right? And but let's start with the assumption that this is a useful test. And then we can allow ourselves to believe that it might be useful in other legal circumstances. And an example that I want to draw on, and that Justice Paciocco alluded to at the end of his presentation, is the ancillary powers jurisprudence, which some of you may or may not be familiar with. And in the interest of time, I'll give a very truncated explanation of it and hope that that suffices. And so, if you assume that the Oakesian type of calculus can be transferred into other legal arenas, and then you allow yourself to understand but obviously it has influence outside of these contexts. And that might change our conclusions about what in fact courts are doing in terms of governance and harm. And these are issues I'll only allude to in today's talk because I think they go beyond the scope potentially of a law talk, but nonetheless I think are important considerations. So Justice Paciocco gave us a small insight into these ancillary powers tests that have been developed over time in Canada. And basically, for lack of, I could give a whole lecture on just what these are. In fact, in my criminal law classes, I do. But of course, what we're talking about here are the abilities of courts to create common law powers, either because it's perceived as some sort of gap-filling function of the common law, something that's always existed that now we're just making clear in our decision, or as others would say, simply to create new common law powers, right, on an ad hoc basis. And I think maybe to give away my impetuous stance here, I might tend to say it's more of the latter. It's a new police power creating test. And that's one use of it. So we see, for instance, in the sniffer dog cases of A&M and Canberra, the creation of a sniffer dog police power, a common law on a reasonable suspicion standard, for example, right? One that hadn't existed in legislation previously, but which the court tells us is charter proof. And so that's the other aspect of it, is it has some constitutional effect as well, it seems. And most lucidly, we see in the arbitrary detention cases, the Waterfield test somewhat adapted, right, and used as essentially the constitutional test for whether detention is arbitrary, particularly in the context of investigatory detention, right? So this is obviously of note, I think, for legal scholars, because it's a British innovation. It's a test that developed in the 60s in a case called Waterfield. That's why you often hear it referred to as the Waterfield test. Lots has been written about why it was used in different contexts there, why it shouldn't apply in Canada. We're beyond that point, and I'm certainly happy to answer questions about that outside of today's discussion. But I think what's interesting to note is, despite the test being articulated in Dedman in 1985 in Canada, it really proliferated in the 2000s, right? So we have at least 7 instances of it being used. I'm thinking of check stop power cases, sniffer dog cases, roadblock cases, 911 response cases, detention powers and searches pursuant to investigative detention powers, all sort of solidifying police power in the context of this ancillary powers test. Okay, so really, I'm going to skip past the next slide here. I do have 2 claims, but I think I'm limited in terms of my time. One, I think I want to urge you to see that there's an affinity between what the courts are doing in these cases and the Oaks test in terms of the kinds of questions they're asking. And I do agree with Justice Paciocco that they do it in a fundamentally less rigorous way, but the same questions are being asked. And where I would disagree with him is I don't think we would stand to benefit necessarily by bringing the Oaks test overtly into the ancillary powers context. And I would say that simply because of this latter point, that there might be critiques about judicial review that have been answered appropriately, even convincingly in the Oaks context, which don't transfer appropriately into the police powers context, just as a matter of philosophy and principle. And so I will pick up on that point in a few slides. We held up a card yet? No? Yes. Well, then I will slow down. Okay, so what does this test look like? Justice Paciocco. I think I can go. No, push the wrong button here. Justice Paciocco discussed the test by putting it up on his PowerPoint presentation, but I'll repeat it just in case we forgot. The quote from cases such as Godway, this is loosely paraphrased, but I eventually move into, you can see it was an airplane presentation. If police conduct constitutes a prima facie interference with a person's liberty or property, the court must consider 2 questions. First, does the conduct fall within the general scope of any duty imposed by statute or recognized in common law? And second, does the conduct, albeit within the general scope of such a duty, involve an unjustifiable use of powers associated with the duty? So here I'm citing Godway, 1999, paragraph 17. And in that second stage of justification, which has an Oaksian refrain to it. We're told we have to think about the totality of the circumstances, and more precisely what is reasonably necessary in the totality of the circumstances. And so when I dissect the most recent ancillary powers cases, these creation of police powers or the constitution proofing of arbitrary detention powers, I do find remnants of Oakes. I find them relatively clearly, even though the court was asked to apply Oakes in some of these contexts and refused, although the dissent certainly did in the case called Clayton. What we see is definitely these artifacts of Oakes. So, searching for Oakes in all the wrong places, I guess. That would have been a better title, more punchy. Next time I'll get that along. So we don't call it a pressing and substantial objective phase in an ancillary powers case, but we do see in these ancillary powers cases a discussion of the crime control rationale, right? A discussion of the crime control objective in terms of what the police are doing. So in Kang Brown, one of the sniffer dog cases, the court talks about the importance, for instance, of curbing the drug trade as an important objective. Or in Clayton, the famous roadblock case at the back of the strip club after guns were reported in a 911 call, you see the importance of curbing gunplay as a crime control objective. You also see public safety entering the fray in the Godoy case, police entry into a home in response to a 911 call that was a hang-up, essentially. We see the paramountcy, not in that constitutional sense, the importance of the public purpose of ensuring health and safety of individuals, and that somehow being more important than the privacy rights of other occupants of the dwelling. So you certainly see this sort of pressing and substantial objective. And it's not terribly surprising, I suppose, because the first stage of the ancillary powers asks us to draw out these common law links. And we know that these common law links, with the fullness of sort of case review, are crime investigatory purposes, keeping the peace purposes for security and order. So it's not surprising that we'd see something like a pressing and substantial objective, but it's there, and I think it's worth knowing. I'm about to see a card, I have a feeling. A 5-minute card. I'll give you some quicker examples of the other phases very briefly. Rational connection, right? Here in the ancillary powers cases, we see a link between the police conduct and the achievement of a police objective. So, for instance, Justice McLaughlin and Justice Binney in Kang Brown talk about the reasonableness of using police dogs in these investigative situations, how they're highly effective tools, how they're well-trained, how they're well-experienced. I have many other examples, but I have less minutes than examples. So I'll move on to an example. I'll stick with the other examples. The example of Kang Brown for a minimal impairment analysis. So again, you see a minimal impairment sort of remnants in the ancillary powers case. Kang Brown, Justices in Deschamps and Rothstein talk about the use of sniffer dogs couldn't have been less intrusive, they write in paragraph 186. This dog merely sat down immediately upon entering the foyer to indicate the presence of a controlled substance. And certainly that language permeates the other cases as well. And then, of course, I can talk about the details of these cases with you at another time. In terms of the cost-benefit analysis that Justice Paciocco alluded to, that's rendered in the language of this totality of the circumstances. So again, in Kang Brown, Justices Deschamps and Rothstein say, in light of the totality of the circumstances, the police in the case of Barr made limited and prudent use of law enforcement tools that were available to them at the time. Okay, so what does this all have to do with Oakes? And it's a good question, other than the fact it seems like they're just lifting, the court is just lifting aspects of Oakes into the analysis, even though they were invited to and had refused to technically. I think, I'll try to do this in one slide, because there's only 3 minutes left. I think what we can do is we can look at some of the critiques and defenses of Oakes and ask how powerful are they in the ancillary powers context, right? So you've heard this earlier today, that through Oakes, hasn't the court merely usurped the legislative function? And this usually is informed by these anti-majoritarian concerns. These aren't our elected officials, how dare they, knows the rhetoric. The court party, the sort of doctrine we hear. Why should courts assume this legislative and political role? Aren't they simply adjudicators of disputes? And tied to this is our complaints as to their expertise. The argument goes something like, this use of the Oakes test is simply the judicial micromanagement of public policy on the basis of limited resources. And those are, that's obviously a caricature of the kinds of debates that arise, but I think what half a slide can do justice to those debates. The answers to these concerns we've also heard today, right? Maybe not in these terms, but we've heard the same justifications here. That there's an element that the courts are empowered to deal with those, basically because of constitutional stewardship or guardianship. First of all, Section 1 empowers them. There's a legislative impetus that empowers them to act under Oakes. Second of all, what we're dealing with here is a post-human rights context, a post-Second World War context. Out of the human rights movement, the idea of courts and democracy is rights forward and rights protective as much as it is protective of parliamentary supremacy. So this sort of feeds into the idea of the dialogue metaphor we heard earlier today, right? The idea that this dialogue can be constructive, a dialogue between parliaments. They pass the law. Courts tweak it, demonstrate in what ways they're not willing to let the Constitution be unguarded. Perhaps on occasion strike the law, or read it down, or whatever the remedy they come up with is. And Parliament has a second key, right? They can redraft. They could, of course, technically override. There's other things they could do. And so I'm not going to move through to the PowerPoint, but I will just say, think of these things in the context of ancillary powers, and whether the critiques and the answers to the critiques apply. So the court has usurped the legislative function. The obvious point here is there is no police powers legislation in these cases. There's complete absences in the common law. If you're a natural law enthusiast, you believe the court is just grabbing these from the ether of natural law and saying, oh, it existed. But we don't have law or legislative edict that we could somehow run through the ringer. So the court then really is engaging in a legislative function, one could argue, right? In a quasi-legislative function. And it's troubling in that it's left actually further problematized by the issues of constitutional guardianship and dialogue, right? And I'll leave you with this thought because I see the words time. In the sense that if, for instance, take the example of investigative detention and test given constitutional effect through a modified Waterfield test, the court gives police new powers for investigative detention by virtue of a Waterfield test, and then says this is also the constitutional test, by the way, for arbitrary detention. So they've just essentially legislated the power, and then they've also claimed to guard it simultaneously, which is very different than the dialogue, right? They're having a dialogue with themselves. So what I would suggest to you is a more apt metaphor would be a constitutional monologue, right? And so I think that raises some profound problems in sort of the wholesale adaptation of ancillary powers of Oakes into tests like ancillary powers. And I would just sort of leave us thinking maybe more sociologically that there's a shift towards using reasonable standards in adjudication, and I'll really wrap it up really fast here. If you had imagine a court where crime was always, where they saw crime as in the offing, a reasonableness standard for the purposes of creating police powers essentially inoculates police after the fact, right? And so if you believe some of the sociological rhetoric that we're moving to a risk-based society, a more secure society, keeping an eye on the wholesale adoption of reasonableness-based tests in other contexts is something we ought to keep an eye on as the law continues to develop, and in some ways reify Oakesian type calculi. So thank you very much, and I apologize for.
Are there any questions as a result of the presentations you heard? I don't think the mic is on. Is it on now? So this is the area for questions. Yes, there's a question.
Yep. Just a...
Grab the mic for you.
Yeah,
just give us 1 second.
It's a good idea to have the microphone so everybody hears.
Clear video recording.
I'm sorry, who had the question?
No, sir. So Professor Jochelson, this is a question for you, and it kind of derives from what Justice Paciocco had to say about that grounded in law requirement, and that requirement in Oakes transitioning over to the ancillary powers doctrine, and whether or not there's a gap there. And my concern is, perhaps you could address this, in having this ancillary powers doctrine that doesn't have that same grounded in law requirement, I think that you start facing inconsistencies and unpredictabilities in the development of the ancillary powers doctrine, particularly when you look at cases like, and contrast things like Kokesh, no perimeter searches versus Tesling, where you have the infrared scanning that is permissible. Then you start getting into developments of what kind of information you're obtaining, and it seems to be a bit more, a bit less predictable. Can you speak to that, whether or not you can have that kind of grounding, you can have that kind of predictability?
I think, is this working? I'll just talk loudly. I think I have maybe a more radical approach to that, and I think as I'm writing a paper like this, I actually in some ways, largely because I'm surrounded by a bunch of left-leaning folks at Winnipeg who have really influenced my thinking. That is loud. As I do this work, I actually come to the conclusion that the creation of police powers by judiciary, full stop, is a policy problem, right? And I look at sort of the Waterfield example, and I think to myself, well, not that the British system of law and order is better, but there is something more elegant about having police powers legislated in a fulsome statute, and then having courts subjected to review, as opposed to courts creating powers on the spot. So it's not so much that the justification analysis bothers me. It's that it's used to justify the creation of new powers by the justices, right? And that alone might not trouble me if it wasn't for the fact that, in addition, in doing so, they're actually derogating from rights of accused in front of them. So, for instance, if you were arrested in the context of a police powers process you didn't know existed, for perhaps a sniffer dog search, and you thought they didn't have the appropriate grounds, it wouldn't be until the Supreme Court decision where you had realized that, in fact, it was a lawful police search. So that intuitively bothers me. The other aspect of bringing Oakes over into ancillary powers that is obviously troublesome is the prescribed by law threshold test, right? And that's where I'm not sure if Justice Paciocco and I would disagree that much, because how are these prescribed by law? You have to really believe wholeheartedly in the idea of natural law, that law is out there ready to be discovered, and that would be the only legitimate means by which a justification test could actually create new power at the Supreme Court level. So in some ways I'd be really comfortable bringing Oakes over if we took prescribed by law seriously, right? But I don't see that actually ever happening, seeing as the court has actually refused to do so. They've just imported the other parts of the Oakes-style reasoning and have ignored the prescribed by law aspect. Although you'll see, if you read the cases, Clayton, Ken Browning, and you see there's a real struggle between the justices about whether this is a legitimate court conduct or not.
I know the question wasn't for me, but I'm going to butt in anyway. I just wanted to say, and let's not kid ourselves about the degree to which prescribed by law actually has much impact, even with statutory provisions. So statutory provisions can be given, they're often worded in extremely general terms. Our doctrine of vagueness is dead on arrival. And you have the exact same problem in terms of the retroactivity of a common law method approach to a criminal provision that, of course, applies to Joe Blow, who happens to be before the court. So I think this is a problem that we have when we have a technically codified system, codified approach to criminal law, but in which the common law method is predominant.
Thank you.
Sir, are there any other questions? We've got another 5 minutes.
What's the prospect of success in challenging these ancillary powers in public interest litigation, for example?
Is that a question directed to?
To anyone who would like to answer it, if at all possible.
It's a really interesting question. I mean, public interest standing generally involves a challenge to law as such, and I am not aware of public interest standing ever being applied to common law rules. I don't think that it would. And I mean, you would think that in principle there should be a mechanism for interested citizens to be able to access the courts. And of course, our original reference function did permit individual women, as the Famous Five did, to have access to the courts. We don't have that, so I think you just have to rely on the right case coming forward with the appropriately motivated counsel who will likely be working for free, and all of the problems that go along with that. I mean, it's a huge systemic problem.
I agree. I think, obviously, standing rules, I think we're about to see some really interesting stuff happen as a result of the sex workers cases going up. Hopefully we'll see Bedford somehow also make its way up to the Supreme Court. So there's an opening in terms of that area, but it's not specific. I don't see it as specific to ancillary powers, right? And I think given that you have essentially 4 times the amount of ancillary powers cases post-2000 as you had in the entire history of the Charter before then, it's hard to imagine there's going to be a wholesale rollback anytime soon. So I'm also skeptical about the political, and yes, I think there is a certain political will at the level of high courts, and I think that you're less likely to see that political will suddenly abate in the context of ancillary powers. But I am optimistic about seeing some coherence and public interest ending in the near future, cautiously.
I think we have time for one more short question.
Justice Brunet, do you have any questions for the panelists?
No, I don't have any questions for the panelists, no. But, I'd like to thank everybody for the interesting questions. I'm glad they weren't asked of me. I'm just going to say, I'm glad those questions weren't asked of me in the microphone. Okay, here we go. I'm going to try this again. I'm repeating myself. Those who know me from the University of Ottawa know that I was an assistant Crown Attorney for a long time. It's all nitty-gritty all the time. We don't deal with a lot of the Oakes tests and so on, because a lot of the time the types of breaches we deal with in criminal trial courts are the types of things that are created by law, they're prescribed by law. Usually it's when police, for example, or some other organization has gone beyond the common law or something that's prescribed. That's when we get into Section 24 and so on, obviously. But it's very interesting to hear the application of Section 1 as it can occur in the criminal context. And I thank Professor Jochelson and Professor Mathen and Justice Paciocco, who's off eating his lunch, no doubt. But I'm going to bring back news. I've been taking notes. I'll talk about it all the way. And thank you for your attention and your questions. Merci beaucoup à tout le monde.